All right, everybody, good morning. It is 9:03 and this is a regular meeting of the Oil Conservation Commission. I am Adrienne Sandoval, Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Also with us today, will our other commissioner please introduce themselves?
Yes, good morning. My name is Greg Bloom. I'm the representative of the Commissioner of Public Lands, Stephanie Garcia-Richard.
Mr. Bloom, you're cutting out. Can you repeat that, please?
Sure. My name is Greg Bloom. I'm the representative of the Commissioner of Public Lands, Stephanie Garcia-Richard.
Is that better? Court reporter.
That was better. Thank you.
Okay. Great. Also with us today is Florine Davidson, clerk to the commission, and counselor to the commission, Chris Molander. First item of the agenda today is approval of the agenda. Agenda items number 6, 7, 8, and 9 have been continued to the July 8th hearing and will not be heard today. Is there a motion to adopt the agenda?
Madam Chair, I move to adopt the agenda.
I second that. Mr. Molander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom.
Approved.
And Madam Chair.
Approve.
The motion carries.
Thank you. Next item is approval of the March 25th minutes. Commissioner, have you reviewed the minutes? And do you approve of them?
Chair, yes, I have read the minutes and approve of the minutes.
Is there a motion to adopt the minutes from March 25th?
Chair, I move to adopt the minutes from the meeting on March 25th.
I second that motion. Mr. Molander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom.
Approve.
And Madam Chair.
Approve.
The motion passes.
Thank you. All right, on to agenda item number 4, case number 21834, application of Wild Earth Guardians and the New Mexico Oil Conservation Division to amend rules 1915-29-6, 1915-29-8, and 1915-29-15 in MAC. Pursuant to 1915-38A in MAC, petitioners, Wild Earth Guardians, and New Mexico Energy, Minerals, and Natural Resources Department Oil Conservation Division apply to the commission to amend the 3 rules as listed earlier. Currently, the commission's rules do not prohibit unauthorized releases of oil, gases, produced water, oil field waste, and other contaminants that occur during oil and gas development and production. The proposed rule would fill that regulatory gap by prohibiting major and minor releases as those terms are defined in the commission's rules. And today we are here to determine setting a date for the hearing, as well as defining the procedural order and how that hearing, if a date is granted, will take place. Do we have, let's do a sound check. Mr. Ames?
Good morning, Madam Chair.
Good morning, I can hear you. Mr. Timmons?
Yes, Madam Chair, I'm here as well. Good morning.
Great, and then Mr. Feldwart?
Good morning, Madam Chair, Commissioner Bloom.
All right, I believe that's all the parties. Okay, well, first I will give Mr. Timmons and Mr. Ames an opportunity to make a brief statement on sort of the petition. And then any sort of proposals that you might have associated with the time frame or the procedural order. And then we can go to Mr. Feldowart following that.
Thank you, Madam Chair. Daniel Timmons on behalf of Wild Earth Guardians. As you are aware, this is sort of a, we're coming back to the commission with a proposal for this prohibition on releases. This started actually sort of back in September with a Guardian's proposal for a prohibition on produced water releases. And then we adapted that into a prohibition filed in October for all releases. We ran into some procedural hiccups with the public notice and some of the issues there. And so we sort of went back to the drawing boards and had conversations with both the division and with NMOGA, and have come together with this joint proposal from the division and Wild Earth Guardians, and have had conversations again with the industry and don't expect any opposition to the substance of the rule. And so, I mean, this is a pretty simple, straightforward proposal that essentially prohibits major releases and minor releases as those are specifically defined already in the commission's regulations, and makes those sort of enforceable violations under the division's authorities. We have worked through a proposed procedural order with the division, commission council, and NMOGA. And so we would request a hearing essentially as soon as possible under the rules and given the public notice requirements. We think given the straightforward and sort of straightforward nature of this proposal, as well as the fact that it sort of has been, the general sense of it has been out in the public already, that we think a 30-day public comment period is appropriate at this point. And our understanding from the timing with New Mexico register publication is that around June 3rd would be the earliest that this could be heard as a public hearing. And so we would request that, shortly thereafter, according to the, the dates that work for the commissioner's schedules, that we schedule the hearing for early to mid-June. Thank you.
Thank you. Mr. Ames, do you have anything to add?
Yes, briefly, Madam Chair, Commissioner Bloom. OCD concurs in Mr. Timmons' proposal for a hearing in 30 days. I would like to add that there does appear to be another party in the matter now. Shortly before this meeting convened, Mr. Andrew Cloutier of Hinkle Shaner entered an appearance for the Independent Petroleum Association. So they just joined the case. I don't see Drew on the line though. So
He was an attendee. I just moved him over to a panelist.
Okay.
My apologies. Can we hear you, Mr. Cloutier? You should be able to unmute yourself now. Maybe.
There I am, yes.
Okay.
Thank you, Madam Chair and Mr. Ames. I apologize, Madam Chair, it was all our fault. I was hired yesterday afternoon, just got the appearance in this morning, so I appreciate the courtesy.
Thank you, Mr. Ames.
Let me, if I may conclude, Madam Chair, we support the proposal to have a hearing in 30 days. As Mr. Timmons pointed out, NMOGA, or Mr. Feldowart for NMOGA, myself and Mr. Timmons provided comments to Commission Council regarding the draft procedural order. And we're hopeful that those changes would be accepted in the main part prior to adoption of the order itself by the Commission. Thank you.
And Madam Chair, can I address that just briefly?
Yep, go ahead.
Mr. Ames, I think almost all the changes were acceptable. There's a few drafting things I've got some of the comments yet I need to address yet, but the parties, I want everyone to know that I'd say probably 95% of those were accepted and work.
Thank you. All right, Mr. Feldowart, would you like to say anything?
Thank you, Madam Chair. Commissioner Bloom, Michael Felderwart with Santa Fe Office of Holland and Hart on behalf of the New Mexico Oil and Gas Association. And I concur that this is really a straightforward proposal that's been put forth here. It really clarifies the existing rule. I think they're correct that the general sense of what this rule seeks to accomplish has been out there for quite some time. So one could also view this as really just kind of not only clarifying, but cleaning up the existing rule. It seems to me that this is a case, given the very limited nature of the amendments, where I doubt that you need witnesses. It seems to me that the party could get together and come up with a short statement of undisputed facts that would support the commission's decision. Following perhaps the allegations, basically that releases occur and that they can pose a threat. Beyond that, I don't see what you would need in terms of a record. So to me, this is a very straightforward proceeding that, in my mind, could be accomplished by the parties getting together with a short set of undisputed facts.
Thank you, Mr. Felderwart. Mr. Cloutier, do you have anything to add?
No, Madam Chair, I've just gotten involved, but I don't want to be attempting to throw a monkey wrench into what the parties have started right now. We're here to participate. With respect to Mr. Felderwart's comments, I'm not sure if IPA would want a witness. I haven't spoken to them, but I would imagine that a witness would be brief, if at all. So.
Okay. I guess just sort of a brief question for Mr. Ames and Mr. Timmons. What do you anticipate the time frame needed for this? Previously, the changes surrounding produced water took 2 days, and it was every minute of 2 days. Do you expect it to be similar to that, less than that, more than that, so that the commission can try to make sure we allot the appropriate time?
Thank you, Madam Chair. I think that sort of the case in chief that I would anticipate sort of in support of this rule, I think could be very straightforward. And I'm certainly open to considering Mr. Felderwart's suggestion of even sort of a written sort of case in chief. I'm not fully sure how that would comport with the public rulemaking requirements. And so I do think that the commission's rules require that there be, a public hearing with opportunity for public comment and testimony from non-parties, as well as the opportunity for other parties to intervene. As we have just had one intervener, I think that there probably is the potential for additional parties to intervene, sort of given the high profile of this sort of issue in general, notwithstanding the very straightforward nature of what's actually on the table. So I would suggest or request that the commission schedule a full day for the hearing. I don't anticipate that it would take that long, but just given the, again, sort of the unforeseen potential of, for other parties and substantial public comment, given what we saw in the produced water hearing, I think that would be appropriate.
Thank you. Mr. Ames, do you concur with that?
I do generally, Madam Chair, Commissioner Bloom. I would not anticipate a hearing nearly as long as the produced water rule. I think the case in chief could be done in 30 minutes, maybe an hour. The open question will be cross-examination, if any, and questions from the commission, and then public comment and non-technical testimony. And it's difficult to predict the latter two categories at this juncture, but I can't imagine that it'll take more than a day, and probably substantially less.
Okay. Commissioner Bloom, do you have any questions for the parties?
Madam Chair, no questions at this time. Thank you.
Okay. Well, I think we need to decide on sort of the ground rules and the timing. My initial, and then maybe if I'm thinking if we talk through it and then we can make motions on the back end. My initial thought is right now we do not have anything on our regularly scheduled June agenda, which is June 10th. So my inclination would be to use that regularly scheduled hearing date. So that we're not packing the month. And I know they're saying one day, but I would feel more comfortable probably blocking off 2 days just because I'd rather free up time than have to go the other way.
Madam Chair, I think that as much as I love the optimism of the parties, I'm going to suggest that 2 days, just because the mix of cases in chief, cross-examinations, commission questions, and then the public comments. I agree with you that it's better to have excess time than to not have enough. So I'm going to suggest 2 days with the anticipation that it could be done at the end of the first day.
Yeah, I agree. Commissioner Bloom, do you have a preference if it's Wednesday, Thursday, or Thursday, Friday? So like the 9th and the 10th, or the 10th, 11th?
Madam Chair, yes, I think reserving 2 days would be a good idea. I'm fine on both ends of that. So I could do Wednesday, Thursday, or Thursday, Friday, whatever works best for you. And of course, I don't know if there's a way to check with Commissioner Engler as well.
Commissioner Engler is unfortunately no longer with us. He has resigned from the commission, and so the commission at this point will be looking for a third commissioner before this date. My thought is to do the 9th and the 10th, just in case it goes over 2 days, then we have the 11th to play with. So that would be my probably thought would be to schedule it for the 9th and 10th, and worst case scenario, we can roll into the 11th. I do appreciate the optimism, as Mr. Moander said, but maybe I'm a little more pessimistic on timing. Okay, so that makes sense. Then I think there are a handful of items. One, I do think it would be beneficial to appoint a hearing officer, similar to how we did with the waste rule. I think it helped everything go much smoother. It was, I think, the first time, maybe in a long time, the commission has done a hearing officer for rulemaking, but particularly with the virtual fashion, it allowed me to be able to fully focus on the testimony and the evidence that's being presented, et cetera. So I would also prefer to have a hearing officer for this. And since we don't at this point know who that might be, maybe what does it designate or allow for me to choose? I don't know what the technical term is, but allow for me to choose a hearing officer at a later date and appoint them outside of a normal commission hearing or meeting. I think that's how we did it last time, wasn't it, Mr. Moander?
That is correct. So we would need a motion, a second, and then a vote to grant you that authority.
Okay. We can do, I mean, is that something you're comfortable with, Commissioner Bloom?
Yes, Madam Chair, absolutely. And just one question on the dates. If we begin on the Wednesday, finish on Wednesday, do we still have our regular OCC hearing on Thursday?
I don't believe so, because this should be the only thing that's on the docket. I don't think we're gonna schedule any extra cases. Unless you just really want to. Okay. All right, so that's the date, the hearing officer, sorry, I'm just making notes. So it looks like we need to set the dates for motions to be filed and responses. Mr. Ames suggested, let's see, all motions be due 10 business days before the hearing. I'm not sure what that date would make it. Let's see. Would that be the 26th of May, maybe?
I think that's the 27th, because 10 business days is usually 2 calendar weeks.
Okay.
So going,
Counting is
oh,
hard.
no, you're right, because it's not over, it would be the 26th. So that's correct, Madam Chair.
Okay. Does that make sense to you, Commissioner Bloom?
Madam Chair, yes, it does.
And then Mr. Ames suggested responses set 5 days before, business days before the hearing. So that would be, I gotta count again here. The
That's
second,
the
I think.
second. That's correct, Madam Chair.
So here, it looks like maybe the suggestion is to have a separate motions hearing. I'm wondering if we need to have a separate motions hearing, or can we hear motions at the actual hearing itself? Any thoughts on that? I know we
Madam
did a
Chair.
separate hearing for the waste roll, but I think it was because we were concerned about the timing or about the amount of time.
So my question is, Madam Chair, if there's going to be an appointment of a hearing officer, seems that one of the key roles for the hearing officer is to handle motion hearings. And so if the commission wants to hear motions on the first day of the rulemaking hearing, I'm not clear what role the hearing officer might otherwise have. I mean, other than maybe running the hearing. So it's just a thought on utilizing that.
Okay, I mean, I don't have a strong opinion either way. 3 days would then make that Monday, right, the 7th. So having a motions hearing on the 7th? Is that what you're thinking?
Madam Chair, I recall during previous rulemaking motions hearing being done on the first day of the rulemaking itself. I'd be comfortable with that, but if there's some entanglement here with the hearing officer, I'd be fine doing it a few days previous.
Madam Chair, another question, and I'm sort of asking this generally to the parties. Given what I'm hearing about the positions of the parties, what are the anticipated motions, just to get, and recognizing this, of course, will change over time, but I'm just curious what the parties might anticipate filing, because it sounds like a motion to dismiss may not necessarily be forthcoming from any particular party, which tends to be a significant motion in rulemaking. So can I get a sense of, or can the commission get a sense of what the parties think they might be filing?
Mr. Moander, Madam Chair, Commissioner Bloom, at this point, OCD doesn't anticipate filing any motions, and I'm not aware that Mr. Feldward or Mr. Timmons anticipate doing so either. But it's entirely possible that another party may enter an appearance in this case. And Mr. Cloutier is still evaluating his position. So it's impossible for us to say what might be filed. One reason for having a hearing on motions prior to the initiation of the hearing itself on the rule is to resolve potentially dispositive issues before we get to the hearing so that we don't get bogged down. And it also would give the parties a better idea of what they're facing when they go to hearing itself and can make any adjustments that might need to in their case to the extent it's consistent with their pre-hearing statements. So I would suggest that a hearing on dispositive motions be scheduled prior to the hearing itself, with the caveat that parties might take exception to other parties' pre-hearing statements, and those kinds of issues would have to be addressed at the hearing itself.
Madam Chair, Commissioner Bloom, Michael Felderwart, a couple things. Number one, and I'll start with what Mr. Ames said at the end. Don't lose sight of the fact that by rule, the pre-hearing statements, which is the disclosure of witnesses and evidence, is filed 10 business days before the hearing. So it seems to me you got to start there and then work backwards or work from that point. And the reason I say that it's not only required, but it's important is because at this point, NMOGA does not know, IPA New Mexico does not know exactly what the applicants intend to present and what witnesses they intend to present, and more importantly, what issues they're going to want to try to raise and address in this hearing. I would think that, and that's why I suggested it might be worthwhile to have some understanding of that if we can't reach a resolution of disputed or undisputed facts, because part of the problem is being put in a position where we are required to potentially address issues that should not arise in this kind of rulemaking and should not be addressed in this rulemaking. I'm hopeful that doesn't happen, but we're not going to know that until we see a disclosure of witnesses or have some sense of what the applicants intend to present, which we do not at this point.
Okay, so at this point, I'm leaning towards let's do a separate motions hearing then. I guess 3 days, because I couldn't count earlier, would be the 4th. So what responses would be due on the 2nd, and then a motions hearing on the 4th? Unless we did it on the 7th, which is 2 days. 4th would probably give people more time to react if needed. How about the 4th?
I'm chair the 4th for me.
Okay, maybe 9 started at 9 on the 4th. We're just rolling through this. Okay, so that I think sets the deadlines. Technical testimony, I did like sort of what we required in the waste rule where for each witness, you didn't have to have written technical testimony in its entirety, but at least like a summary of what each witness was supposed to present on, as well as anticipated timing. So I would like to see that again. I think it made it easier. And then on non-technical testimony, maybe Mr. Moander, could you do me a favor here and help me understand the distinguishing factor here between non-technical testimony and oral public comment?
So are you referring to the rule, or are you referring to the draft scheduling or procedural
The
order?
draft scheduling, the draft procedural order.
So I think Mr. Ames he's I think proposed some of that. If I'm looking at this, and I'm assuming you're looking at, and I got to do the formatting, but it should be the first indented paragraph under non-technical testimony. Any person that wishes to present non-technical testimony or non-technical testimony. The way I understand it, and I'm always happy to hear the parties comment, is that even if you're going to give some sort of comment, like a public comment, or you, in other words, really, if you're going to speak about technical aspects of this rule, you're going to need to file a pre-hearing statement, sort of period. And it's not going to be permitted if you show up to make comment without having filed a pre-hearing statement to give public comment that is technical testimony. That's one of the things I want to talk with Mr. Ames a little bit about, so maybe I can parse the language a little further. But if it's non-technical testimony, then they get one opportunity to speak, and that's it, and that's the public comment. So maybe I'm not clear on what we're wanting to do, because I felt like the order was fairly clear there, but I would happily listen to Mr. Ames.
Madam Chair, if I might.
Please go ahead.
Thank you. Mr. Moander, first, I don't deserve credit for the edits to the procedural order. I need to share that with Mr. Timmons and Mr. Feldwert. But with respect to your question about non-technical testimony, my understanding is that, as you said, if a person wants to present technical testimony, they have to enter an appearance and file a pre-hearing statement. Anyone else can speak to the commission, and there are two paths they can go. One is public comment, the other is non-technical testimony. The only difference is that a person wanting to present non-technical testimony will be sworn and subject to cross.
Okay.
Full stop. Full stop. As far as I'm aware, there's no other distinction.
All right. I mean, I guess I'm fine with keeping the distinction in there then. But I do want to, I mean, let's see, I think the formatting needs to be updated, but that's easy. The second, I guess, sub part of non-technical testimony, it says any person that wishes to present non-technical testimony shall notify the commission by signing up on the date on which the person wishes to be heard. I just think we need to set some time parameters, and same thing with the oral public comment. Again, I think that was a successful way to do it during the waste rule. I think we had confusion we found during the produced water rule back in the summer. And so it's like setting time parameters, like comments going to be from X time to X time, and you've signed up during this hour or 30-minute block. So I sort of want to put that in here. I know it's a little bit different with a shorter hearing. But the way I think it's written right now, it sort of sounds like if I decide that talking on Thursday at 2:30 works best for me, then I'm going to sign up for that time, and that's what I'm going to get. And I don't think that's how it's exactly going to work. So we need to like set a time parameter that works for the structure of the hearing. Not knowing how much we're going to get and how many days it's going to go makes it a little more challenging. I sort of think we start off with public comment. And so if we're doing, I don't know, 2 hours, 3 hours, we can say 2 hours specifically, but if we don't have enough people signed up, 2 hours for what we did for the waste control was like 2-minute slots. So if we don't have enough people signed up, right, then I want it to be structured so that we can go ahead and start the hearing. I think it was a little, we had issues with that during the waste roll hearing, like it wasn't structured that way. So we had to, even though we didn't have enough people signed up in the time slots, we had to wait. So I'd want it structured that like once public comment was done, we can move right into the hearing or the testimony part of the hearing or vice versa. If it takes more than 2 hours, it takes more than 2 hours, but we need to have the sign up ahead of time so that we can have it structured and coordinated. And that worked so much better in the waste rule. That was a lesson learned from last summer.
Madam Chair, the order can be modified to include these particulars. I don't think that's a problem, including something to the effect that all individuals that timely signed up upon completion of comment, the hearing may begin, or something approximating that. The other thing too that comes into play is if we do comments, so anytime we're going to have commenters at the hearing, the parties obviously need to be present. So if we run into a large volume of commenters, that may be where we have to look to the second day to incorporate that. And then I would recommend we do that before party closing. Preferably, I suspect the parties would agree with that any comment on, say, the second day or even the first day would need to be done ahead of closing. So if there's cross-examination needs done or anything like that, or it permits the parties to address those comments if necessary.
Well, it sounds like we're going to have a day 2. So, okay, my initial thought, Commissioner Bloom, let me know what you think here. My initial thought would be to set aside 2 hours on the morning of the 9th, and then set aside, go ahead and commit to we're having a second day. And, even if the testimony and all of those pieces conclude the day before and say it's 3 o'clock, right, we'll just break until the next morning, and closing arguments can be after the public comment concludes that next morning. And then we also, need to, we can decide at the hearing whether or not we want to go directly and do deliberations or do it another way. Okay, so my thought would be 2 hours on the morning of oh God, I wonder if 2 hours is going to be enough. Let's say 3. Let's say 3 hours, but Chris, I want to make sure it's structured that like if we don't have people that fill that entire time, that we can go ahead and start.
That can absolutely be placed in the order, and I'll draft language to that effect.
And then what, 30 minutes or an hour the next day? I don't know, Commissioner Bloom, what do you think? I'm sort of like throwing out times.
Perhaps we could, Madam Chair, begin with 1 hour reserved for public comment, and then again, immediately upon public comment ending, should it end early, we could then move into closing statements.
Okay, that sounds good. So that would be what, 9 to 11? No, 9 to noon on day 1, and day 2, that would be 9 to 10, will be reserved for public comment. Individuals need to sign up prior to that time frame to comment. So they need to sign up prior to the morning of the 10th, or I would say the night before. They need to sign up by the night before so that we're not trying to manage a bunch of people that morning and maybe miss somebody. So I think sign up before, what is it? The night, the evening of the 8th, something like that.
That can also be addressed. I know that's doable.
Okay.
Madam Chair, Mr. Melander, this is Daniel Timmons with Wild Earth Guardians. I do just want to point out, according to the rules, 1915 3.11, section A1 states a person does not need to file prior notification with the commission clerk to present non-technical testimony at the hearing. I would think that I would recommend that you request prior notification and folks sign up, but then open up the floor at the close to ensure that we comply with the regulations.
Mr. Miner, do you have any thoughts on that?
I'm having some technical difficulties here. I'm trying to pull up all the rules to go over these again quickly, so I'll need just a minute.
Madam Chair, the commission, while we're waiting on that, as I alluded to earlier, the one problem I see with the motions being due 10 business days before the hearing is that is the same day that the pre-hearing statements are due. It seems to me that you would want to have the pre-hearing statements filed first and then have your motions day after that, because I would suspect that the pre-hearing statements are going to be what may foster some type of motion.
And Madam Chair and Mr. Commissioner Bloom, Drew Cloutier here, and I concur with Mr. Feldwart.
What would your timing proposal be, Mr. Feldwart?
I think we could file motions on the 31st. That would, so if the pre-hearing statements came in Wednesday, the 26th, that would give you 2 business days plus the weekend to file motions on the 31st of May.
Madam Chair, OCD doesn't have any objection to structuring the process in that way, although I would point out that in the venting and flaring rule, we had a motions hearing prior to the hearing itself, and the parties all understood that they could file additional motions based on pre-hearing statements, and that those would be heard at the hearing, at the rulemaking hearing itself. So in the venting and flaring rule, in other words, we had a 2-stage process. Mr. Feldworth and Mr. Cloutier have proposed simply consolidating all the motions into one hearing, and I don't have an objection to that. I think that may actually be a better practice overall.
Okay, so Mr. Feldwart, your proposal is pre-hearing statements due the 26th. Motions due the 31st. Then we would have responses due the 2nd. Then motions hearing the 4th.
That's tight, but that's fine with me, Madam Chair. You know, I think we don't have an option under pre-hearing statement, right? That has to be filed on 10 business days. That's where we don't have an option. Everything else we have some flexibility on.
We just like to keep it interesting here at the OCC. We don't want anybody bored. I'm fine with those revised dates. Commissioner Bloom, Mr. Reminder, do you have any preference on that?
Madam Chair, I have no problem with those dates. I would just note that 31st, I believe, is Memorial Day, but that shouldn't stop anyone from submitting their motions. So.
Happy holiday.
So as a general rule, all right, so we've got a whole lot of stuff on the floor here.
We
So
do.
Can I catch those dates again? Because I was parsing the rule based on Mr. Timmons' statements earlier. So what was the proposed motion deadline or motion deadline?
Proposed deadlines for Mr. Followert are pre-hearing statements on Wednesday, the 26th. Motions due end of business or end of day, whatever, the 31st, which is Monday, which is Memorial Day. Responses due the 2nd, which is Wednesday that week, and then the hearing on the 4th.
Okay, so a few comments on that. Mr. Felderwert's right about the pre-hearing statement. That works, and these motion deadlines work. One thing I will address, realizing this is not court, is customarily filing deadlines that fall on a state holiday roll over to the next business day. The commission it has some latitude there, but I always just put that out there as sort of a matter of course. Something just to consider. If the parties are fine with having the 31st deadline, I'm fine with that as well. Stepping back briefly and looking at the non-technical testimony, I will confess I'm still pretty vague on the difference between a public comment and non-technical testimony, because it seems to me that essentially all public comment is non-technical testimony because there's nothing that distinguishes the two in the rule. And so Mr. Timmons is right that it says that they do not need to file prior notification. I'm also not clear whether that means they're signing up for a slot versus notifying the commission that they're going to comment on a particular topic. This is always the problem with regulations, is that some of this stuff isn't necessarily outlined or defined. So I'd like to hear from the parties on that, because when I think of notification, I tend to think along the lines of, here's my name and here's what I plan on talking about when I get my opportunity, rather than signing in. But as a corollary to that, under 11A3 says that sign-in would need to be sign-in sheet at the hearing. I'm not even convinced that's the same thing as a sign-up. So I'd like to hear that discussed a bit, because I do have some concerns about those distinctions.
Mr. Timmons, you want to give it a go first?
Thank you, Madam Chair. Mr. Moender, I certainly concur with the general sentiment that the distinction between public comment, or which I interpret to align with what is referred to as an unsworn position statement in the rules. And so I have been using the term, I think Mr. Ames in our comments was using essentially the term public comment as analogous to unsworn position statement, because the distinction that we identified, or that I should just speak for myself, that I've identified is yes, that the swearing in and the opportunity for cross-examination is the distinction between public comment or unsworn position statement and non-technical testimony. There may also be, or a distinction could be made in terms of the time that would be allowed for a public comment versus a sworn non-technical testimony. Obviously, if the opportunity for cross-examination is taken, then that certainly could go longer than 2 minutes. So that would be sort of the other distinction there. Again, I do think that sign-in sheet at the hearing language, as well as the not needing to file prior notification, for me, I interpret that to mean that it would likely potentially be improper for the commission to require sign-in prior to the hearing. Again, I think it would be entirely appropriate for sort of logistical purposes to request that. and to highly encourage folks to do that so that we can sort of manage our time most efficiently. But I would encourage the commission to make available an opportunity for folks that have not signed up prior to the hearing to be allowed to speak.
Any other parties have comments on that?
Madam Chair, this is Eric Ames for OCD. I completely concur in what Daniel said. He framed it very well. Thank you.
Madam Chair, if I can actually just add one additional thought.
Go ahead.
Just thinking in terms of a way to encourage people to sign up beforehand, maybe you could give them 3 minutes if they sign up beforehand and limit them to 2 if they sign up at the hearing. Just in terms of providing the opportunity, but yet also trying to give folks incentive to sign up ahead of time.
Madam Chair,
Go ahead.
Commissioner Bloom, sorry, and Mr. Molander, I think the distinctions we're dealing with here, if you look at the rules, 1953-10 deals with what we would term public comment, okay, which is written comment to the proposed rule that's sent into the division. Okay, that certainly is dealt with, and you can deal with the timeframes for that. We then have the second category, which is a person who may testify or make an unsworn statement at the rulemaking hearing. That is what Mr. Molander referenced in subpart 1915-311. That does have a sign-up sheet at the hearing requirement to it. I know we're all in a virtual format, which makes it more difficult, but that's essentially the distinction. Those who want to provide public comment in written format before or during the hearing, or if you allow after, and those that actually want to say something at the hearing. And those that want to say something at the hearing are either sworn or they're not sworn. And that is the sign-up requirement.
Mr. Cloutier, you have anything to round out the discussion?
Nope, I again agree with Mr. Felderwart. This is a rare day.
We'll mark it down in history. Okay. I definitely want to make sure that we can give everybody, the opportunity to comment as they like. I think we want to strongly encourage people to sign up, just because it's going to make the process better. I am fine with doing you sign up before you get 3 minutes if we want to go that way. You show up at the hearing, then you get 2 minutes. The other thing, and this is what we did in the waste roll hearing, is we, what was it? 20 people per, because it was 2 minutes at that point, 20 people per block of an hour time frame. And so you were able to know, okay, well, I know I'm going to be from 9 to 10 on this day, which was a benefit to people, because one of the complaints we have heard in the past is like, how do I know when it's going to be my time? So maybe we can try to do, I would like to try to do that. Where they sign up for, like maybe we could, since it's a shorter time frame, do 30-minute blocks, 30-minute blocks with 10 people in them. So to allow for 3 minutes or 2 minutes really, and have a little bit of extra time. So maybe they sign up for 30-minute increments with the commission clerk. And then they know what 30-minute block they're going to be in. And then, at the point where if it's somebody who just shows up at the hearing and wants to speak, they get an opportunity when they get an opportunity. Whenever sort of comment ends at that point. Or it might have to be, so that might be the benefit too, is they have a set amount of time, so they're not just, I don't know, Commissioner Bloom, do you have thoughts?
Madam Chair, you've done this much more recently than I have, coming particularly off of the Benning and Flaring role. I think you're headed down the right track. The suggestions sound good, so I'm fine with any of this. Thank you.
Okay. All right. So summarizing that, I think, Mr. Miranda, 3 hours on the first day from 9 to 11. Encouraging people to sign up with Commission Clerk prior to that date. Anybody signing up prior to that date will get 3 minutes. And they will be signed up in sort of 30-minute blocks with a maximum of 10 people in a 30-minute block. And if you show up at the hearing, you know, we can't guarantee what time it will be, but, you know, everybody will have their opportunity, and they will get 2-minute blocks to make their statement. And then an hour scheduled for the next day, but in both situations, make it clear that if we finish prior to, you know, sort of those time blocks, we will move, you know, straight into either the technical testimony, closing arguments, whatever it may be, sort of at that point in the hearing. My only question is, how are we supposed to distinguish the technical versus non-technical, or I'm sorry, the oral public comments and the non-technical testimony, i.e. who gets sworn in and who can be crossed? I don't, how do we distinguish that? I mean, is it like a, I'm
Madam
unsure
Chair?
on that piece. Yeah.
Madam Chair, I think the way you distinguish the two is to ask the commenter whether they, or ask the person who wishes to speak to the commission whether they would like to be sworn and present non-technical testimony, in which case they'd be subject to cross or not. And at that point, you, if they want to be sworn, they get sworn and they're subject to cross. If not, they proceed with their public comment.
Madam Chairman, I'm inclined to agree with that because I do not, and based on my admittedly some limited experience with these rulemakings, I don't know that most commenters are going to necessarily understand or even frankly care about the distinction all that much. So I think that goes on the table, and I could certainly put that in. I mean, granted, the procedural order is mostly for the benefit of the parties. But at the same time, we can put that in there that the parties will be offered that opportunity, you know, to be sworn.
And I think make it clear and crossed. I think that's the, yes, it's important to understand, but I think the and crossed is a big distinguishing factor.
I think that's the primary one, but yes.
Yes.
And that puts them on notice. The parties are also now aware of this as well. So, you know, this is one of those things where we just got to make sure, both from a commission as well as a party standpoint, that this is what we're going to do. So that way, anyone that may be offered up for comment, hopefully, will be aware of that even before they speak.
Okay. Great. I think we have nailed that piece out now. I think that's sort of my last, I think that's really kind of the last item. Oh, written public comment. Can't forget that. So what is the date that this like technically gets published? Because isn't that when, I guess, technically the written public comment starts?
Yes, Madam Chair, and I'm assuming, since we've worked so hard on this cumulatively, that this would, the next publication deadline is the 22nd for May 4th. So we would open, I would think, public comments starting on May 4th if we wanted.
May 4th, and it would run through the 8th?
I believe that should work, because 30 days from in May would get us to like June 3rd or something like that. Yeah, I think it's June 3rd. So with that in mind, you could have it run up to the 8th. There's no issue there. 'Cause, I mean, the real question is, how do the comments get handled, collated, and disseminated? But I think we've already got that under control.
Yeah, I mean, my inclination would be to have it run as long as kind of feasible, which would be the 8th, the day before, by end of business on the 8th. Commissioner
Yes.
Bloom, what do you think? I can't hear. I don't, maybe you're muted.
You hear me now?
Yeah.
Yeah. Okay. That date that sounds fine to me. May 4th, June 8th, just provided we're giving the staff enough time to get everything collated and submitted. Perhaps look at the dates one more time in June here. Perhaps we'd want to say if we're beginning right on the 9th. What if we say close of business on the 7th, and then that gives staff time to pull together comments and us time to review them?
That's fine with me. And we did this with the waste rule, and I would be inclined to do this again. I know, like, technically, right, the public comment period starts on May 4th, but we accepted public comments before that date, written public comments. And I don't see any reason not to do that again.
I don't think it
starts-
hurts. I mean, because we've got the formal comment period. I know unless parties have a particular objection to that, I don't see any negatives from it, other than more paperwork, but that's implicit in the process.
Commissioner Bloom?
I'm sure I would be fine with that.
Okay. Okay, I think now that's the last piece. Which parts of this do we need to make motions on, Mr. Melander? I sort of I have notes.
So I think the first thing we want to address is the granting of power to you, Madam Chair, to appoint a hearing officer. And so that's the start. And then assuming maybe what I should do is kind of go through my notes and additions, so that way the key components of the scheduling order are addressed. And I think actually, I tell you, could I have a couple minutes to go through the actual draft that I've circulated and just make sure there's nothing that's missing before we address that? But we can do the vote on the appointment right now and just get that out of the way.
Okay.
All right, then, Madam Chair, I move to empower you to appoint a, that's what I'm looking for here, manager for the purposes of the spill rule.
I second that. Mr. Melander, do we need to be more specific, or is that okay?
No, that's fine. Just granting you the power to appoint a hearing officer, short and sweet. So with that
Can we
in
do a roll
mind,
call vote, please?
I absolutely will, Madam Chair. Commissioner Bloom
Approved.
and Madam Chair.
Approved.
All right, the motion carries. All right, I just need 1 second to take a look at this order, and
Do we
I will
want to
be
take
right-
a 5-minute break? Would that help?
That would be wonderful if you would so indulge.
Okay, why don't we come back at 10:12?
Excellent.
Very good, thank you.
part is key. If we have longevity, we have a longer time frame until we retire, we have more time for our dollars to be investing, those dollars to be growing, and for us to not have to pay taxes on any of that growth. So the Roth can be a great advantage from a tax perspective.
How's it going, Mr. Molander?
It's going well. Looks like we've got every date that we need set for or capable of being put into the order. So I'm satisfied.
I'm sorry,
and
are we back on the record?
oh, yeah, we are as of right now.
Or let's make sure Commissioner Bloom's back.
Oh yes, we need everybody, don't we?
The whole gang. All right, I think we have Commissioner Bloom now. All right, go ahead, Mr. Molinder.
In reviewing the proposed scheduling order, it looks like we have all dates and times that are necessary for entry into the procedural order. So unless any particular party needs to or wants to have those recited, I think we're good to go.
Mr. Moender, Madam Chair, Daniel Timmons with Loud Earth Guardians. I actually, just going back through the rules, do have one other comment with respect to the close of the written public comment period. Reading the rule with respect to that, 1915.3.10, a person shall provide written comments on the proposed rule change to the commission clerk not later than the date of the scheduled hearing, unless extended. My interpretation of that rule, and I just had a quick conversation with Mr. Ames, believe that it's not clear that the commission has the discretion to shorten that public comment period. And so I would suggest that I realize it's inconvenient and somewhat unfortunate the way the rules are written, but would request that the written public comment be allowed to continue through the first day of the public hearing.
I don't have any strong opposition to that if that's how the rule reads. Mr. Bloom.
Madam Chair, yes, Mr. Timmons, thanks for flagging that. I guess it's the unfortunate reality. I prefer to have things in front of me a day or so ahead so that I can have time to review them and study them and give the public comment the attention that it's due. But yeah, we'll be reading them as they come in during the hearing. Fantastic. Thank you. Madam Chair, you're muted. Sorry.
Well, I'll try again. Do we need to make motions on any of the other items, like the date of the hearing or any of these other sort of procedural items, or does that get wrapped up in the procedural order?
With the procedural order, as it's written, I would suggest, just for the sake of completeness, that the commission, essentially one of the commissioners, move to adopt the dates and times as discussed to be reflected in a procedural order.
I'm happy to do that. I have them written down. Okay, I move that hearing and the rulemaking hearing in case number 21834 be scheduled for June 9th and 10th. And that the pre-hearing statements are due on May 26th. The any motions are due on May 31st. Responses are due on June 2nd. And that a motions hearing be set on June 4th for 9 a.m.
I second that motion, Madam Chair.
Mr. Moander, will you do us the honor?
Yes, Madam Chair. Commissioner Bloom.
Approve.
Madam Chair.
Approve.
Motion passes.
Great. All right, well, I think that concludes case number 21834. Next up on the agenda is case number 21744. Application of Cimarex Energy Company for hearing de novo of case number 21629. Do we have Mr. Savage and Mr. Padilla?
Good morning, Madam Chair. Darren Savage here.
Good morning. I think maybe Mr. Padilla, are you muted?
Now, Ernest Padilla for Colgate Energy. Operating, I'm sorry, Colgate Operating LLC.
All right, so we have received additional information following the last OCC hearing where we requested sort of additional documentation from both parties. And that was submitted and I believe has been reviewed by both commissioners as well as council. I will give you each, a brief moment to sort of add any additional information. I mean, keep in mind that the commissioners have read the documentation you have already sent in, so you don't need to repeat that. But if there's any information that you would like to add, Mr. Padilla, please go ahead.
Madam Chair, Commissioner Bloom, I think the preceding conversation and discussion in the rulemaking proceeding was very educational as far as our position is concerned. For a party to participate in a rulemaking proceeding, and especially in an adjudicatory proceeding as compulsory pooling, a person such as Cimarex has to make an appearance beforehand in the original proceeding. I heard Mr. Moander say, and I tried to quote what he said, here is my name and this is my topic in the rulemaking procedure that you just had before you. And that's exactly what we're arguing. In order to become a party, you have to sign up and you have to say something. You don't even have to say anything, but you have to sign up before the hearing. Everything that was discussed before in your rulemaking case requires some procedure for the benefit of parties. The word was thrown around multiple times about parties in your prior case. And that's exactly what we're arguing. You can't simply say, after an order is issued by the division, oh, by the way, you weren't fair, or we have this problem with not having a hearing, not being in the hearing, because essentially what Cimarex is arguing is the dog ate my homework, so therefore I ought to be allowed to come in after the hearing and come before the commission. The commission has real important proceedings before it. This rulemaking procedure is illustrative of that. If you open the door to anyone after an initial order is issued, other than for lack of notice, and this is not a lack of notice case. Cimarex had notice, they did not participate, and they offer a pretty good excuse, but Cimarex is a big company. I've litigated against Cimarex in the Federal District Court, and they're tough. They hire top-notch lawyers to represent them, and I don't think there's an excuse for them not appearing at the original hearing before the division. I think the rules are clear. They require that a person who asks for a review of the commission be a party of record. I think we tried to do that in a supplemental brief. I don't want to go read the rules all over again, or I think it's very clear. But I do think that the commission is going to open a can of worms for anybody to come back and say, I'm aggrieved, I don't like that compulsory pooling order. Now, Cimarex argues waste and relative rights and that kind of stuff. That's not even relevant here. What's relevant is that they should have participated in the original hearing of which they had notice, and they're not entitled to a commission hearing. And I'll stop there because I think to go into what I wrote and what we filed on the supplemental brief is very clear. The cases we cited support the fact that someone who does not become a party does not have the right to appeal. And in this case, they don't have the right to, Cimerex does not have the right to a review by the commission in a compulsory pooling case. They're protected by the order that was issued. Their correlative rights are protected. I'll stop there. Thank you.
Thank you. Commissioner Bloom, I guess my thought here is let both parties sort of make their statements and then we can ask questions as needed. Does that work for you?
Chair, I concur. Thank you.
Okay. Mr. Savage, do you have anything you'd like to say in response?
Yes, thank you, Madam Chair. Commissioner Bloom, Mr. Moander, good morning. Darren Savage on behalf of Cimerex Energy. So this has been fully briefed, as you point out. If the commission still has concerns about altering policy, this case should be decided in Cimerex's favor based on the very narrow fact that Colgate failed to fulfill the statutory mandate of 72-13. This is really all you would have to look at. The statute requires that the division shall cause a complete record to be made prior to the issuing of an order. That provision, New Mexico Supreme Court has ruled that shall in a statute denotes a mandatory, that the provision is mandatory, and Colgate failed to provide a complete record on which to base the order. At this point, it should be clear that the order as issued is invalid. The decision to grant Cimerex a de novo hearing under this basis alone would in no way threaten the existing policy of current procedure and would not set any new precedent, but would uphold existing precedent by making it clear to applicants what is required under the statute, that applicants would not expect the division to issue an order until they submit all necessary documentation and complete the record in conformity with the statute's mandate. The basis for granting a de novo hearing on this basis would be limited to this one fact and one issue. And there's no excuse for Colgate to have not completed the record and satisfied the statutory mandate. It promised the division that it would do so, but it did not. Whatever consequence Colgate now faces for this failure, Colgate brings it upon itself. That is really the strongest argument in this. In response to Mr. Padilla's comment on that proceeding is only the hearing and that an entry of appearance needs to be made prior to the hearing or at the hearing. Clearly, the regulations do not state that. They make it very clear. They have two separate independent phrases, independent clauses. One clause is that the party can make an appearance at any time in the case to be a party to the proceedings. And then the other option and the alternative is if that the party can make an appearance at the hearing. And there's a very important reason for this distinction, and that is because a proceeding, by definition, like for example, if you look at the Black Laws Dictionary on the definition of proceeding is clearly defined as the natural and orderly progression of an adjudication from the point of commencement to the point where there's an entry of judgment. And that's the scope of that basic definition encompasses more than just the hearing. And that's why the regulations are drafted and constructed in this manner. The proceedings did not conclude under that definition until January 20th. And we made our entry of appearance prior to that. January 20th was when the entry of the judgment was made into the public record. And also Cimerex would argue that in this particular case, actually the proceedings did not end until January 27th. And that was when Colgate finally completed the record. It seems conclusive that there needs to be a ruling in favor of Cimerex under these facts and circumstances. Cimerex also provided a full outline if the commission should decide that it wants to expand its authority. It can do so by expand the policy. If it decided to do that, it can do so, and there's good reasons why to do that. And there's benefits why to do that, but that would be something the commission would have to decide. But they can do that, and they can still maintain proper due process and proper procedure. And so either basis that we provide, we ask that the commission grant Cimerex request for a de novo hearing. Thank you.
Thank you. Mr. Bloom, do you have questions for the parties?
I may, Madam Chair, but if you have questions, I would offer that you ask them now and I might follow up.
Okay. So Mr. Padilla, sorry, I'm trying to get on the right page here. Cimerex, in their brief, asserts that not all of the requirements for compulsory pooling were followed, and there was not sort of the good faith effort to contact and get the other parties on board. Do you have any response to that?
Yes, very often there are supplemental requirements that come out at a hearing. For example, I think in this case, if I'm not mistaken, it was the C-102 that was needed to be supplemented. And so there's room to supplement hearing officers' requirements. It doesn't change it's not a jurisdictional defect. It's just one of those things that slips by every once in a while. But on the record itself, the record is complete, and hearing examiner will ask for supplemental material that was not turned in. But it doesn't go to the merits of the case, doesn't go to notice. If that was required, then I would agree that a notice issue would definitely have to be satisfied, or at least additional time had to be made in order to comply with the rules of the division. Notice is something that I would easily concede if Cimerex had not had notice. That's a jurisdictional effect, and that is. But in terms of a ministerial type of supplementation, that happens quite often, where someone asks for and a C-102 is generally where there might be a well change, and testimony at the hearing will say that the location, say the bottom hole location, is changed, but it's still a standard well location. And so you have to have an amended C-102 or something of that nature, but it doesn't change the substantive nature of the case. So in this case, it was nothing that Colgate couldn't supplement. Everything was in there. To try to make a case that the record wasn't complete when clearly there's a custom and practice at the division to supplement minor stuff, and this is what Cimarex is arguing now, that it didn't complete the record, but in fact, an order was issued before all of that. An order would not have been issued had that been a jurisdictional problem or any, something of that nature. So to say that the record was not complete the way custom and practice at the division does not change the matter. The fact of the matter is that Cimarex did not appear at the hearing, and I think the law is clear that in order to ask for review in court or in administrative proceedings, you have to be a party. They're not a party. They're not entitled to review before the commission. Now, understandably, if there's a legitimate de novo hearing, you can start all over again and before the commission. But for the commission to not follow the party of record regulations and the statutes, it's not a policy, it's what the rules and the statutes say.
So Mr. Padilla, I'm gonna
just— You're not expanding a policy, I'm sorry.
I think we went well past my question. So walking back to what my original question was, though, you started talking about notice, which notice is different than sort of the obligation or the not requirement, but the one of the standards in compulsory pooling to engage in good faith negotiations. Was that done by Colgate?
Well, as far as Colgate is concerned, there was. That's what their position is. The Cimarex should have come and argued that at the hearing.
Okay.
We litigated that issue before the division often, where we contend in some cases, I know I've argued that good faith negotiations did not occur.
And okay, so my next question then would be,
if you don't appear, forgive me, Commissioner, if you don't appear, then you waive the right to make that challenge.
So what is your interpretation of party of record? Is that you believe that term is solidly defined by either the act or the rules?
I think that it's solidly defined the way we have. I quoted a lot from the rule itself as to what a party is and what a party of record is. Party of record that does not appear does not even get an order. And the rules that we cited in the supplemental brief, and we had already done that before, was 19.15.4.24, dealing with copies of commission and division orders. Who gets those? And it's parties of record. Now, if you go to the definition of parties to adjudicatory proceedings under 1915.4.10, they got notice and they should have appeared. That's very clear, and it's in harmony with 70-2-13. And I don't know, in order to argue that you did not, that Cimerex in this case did not, or that Colgate did not, in good faith, make efforts to seek joinder, then you have to argue that in the division case. Otherwise, you know, now, if they had appeared and argued that and they still lost, then you could go seek review before the commission.
Okay, thank you, Mr. Padilla. Mr. Savage, I'll ask you the same question. Do you feel like party of record is clearly defined in the OCD rules or the Oil and Gas Act?
If I can answer that, Madam Chair, in the context of addressing Mr. Padilla's comments, I'd like to do that, and I'll get to that question directly. So there is some flexibility in the submission of the exhibits, and you know these cases are really complicated. They involve lots of information. I myself have put on the checklist that I would you know, submit the client's exhibits the day after, the same way Colgate has. And you know, as practicing before the OCD, we appreciate that kind of flexibility, because you know, a lot of these times these cases can be very unwieldy. But the point of the statute, the clear point of the statute and the statutory mandate, is not that an exhibit can be submitted after, you know, in a timely manner after the hearing. The point of the statute is that the OCD cannot render a decision until it causes a complete record to be made. And in this case, Colgate had the opportunity to complete the record prior to a decision being made, and it even promised, it assured the division that it would, but then it did not do that. And unfortunately, the division issued the order and made it of record before the statute was satisfied. And Mr. Padilla even points out that a lot of times C-102s are submitted after the hearing, is because during the hearing things come up and there actually are material changes made within the location, and the C-102s change. So if there's material change on the C-102, that is something that is essential for the division to review prior to issuing the order, because all material changes must be accounted for in the complete record prior to an order being issued. So the C-102 is not just, you know, some kind of ancillary supplement that's trivial. It's very critical to the nature of the development of the unit.
Mr. Savage, what do you know if that change was what you would term a material change or not?
We don't know, because it was not adjudicated. So we don't know if there was a material change or not. And that's left unanswered. I mean, you could probably review it at this point and see if there was an obvious material change, but of record, we don't know. That is not something that has been determined. So if I could point out, so if I can answer the question directly, or respond to the question directly, is Cimerex a party of record under the statute? So here's how I would answer that. So Cimerex made a written appearance in the case on January 19th, and this was prior to the entry of the judgment So under the basic definition of proceedings, Cimerex became a party to the proceedings under the regulations. The record was not complete. The record would never have become complete because the OCD had issued the order, and so there was no incentive for Colgate to complete the record, and they did not do so until Cimerex made an entry of appearance of record. So Colgate responded to Cimerex's appearance by submitting documentation of record. So that is a direct response that extended the scope of the proceedings to that date, and they did it directly in response to a party who made an entry of appearance of record. So based in that context, it looks to me like, since the statute does not really define what party of record is, and neither do the regulations and past commission orders acknowledge this, within that context and the facts of that context, clearly Cimerex is a party of record.
Do you believe that the division made an error in issuing that order?
I believe that the division is very busy, and they deal with a lot of cases, and I believe it's the responsibility of the applicant to ensure that the division has all the materials, documentations, and exhibits on which to base a decision. So it was an easy oversight, given the docket of that the commission, that the division deals with. It's unfortunate, but I think it's a critical event in the proceeding.
In your supplemental brief, you bring up a new energy case. I think it's new energy economy.
That is correct.
And in that case, it sort of goes into the test for determining a party of record is, one, did the aggrieved party submit any evidence or argument in writing? Did the party examine witnesses at the hearing? Did the aggrieved party enter an appearance prior to the closing of the record and fail to supply acceptable excuses for the untimely entry of appearance? And 4, the reportedly aggrieved party moved to reopen the record for the case or offer to submit any new evidence. I mean, do you believe that Cimerex sort of meets that test?
Madam Chair, at this point, we're looking at 2 options that would provide a basis on which a de novo hearing should be granted. One, as I pointed out, is the failure to satisfy the statute 72-13, which those factors do not come into play. That's a very narrow set of facts, and there's justification to base the de novo hearing on that alone. On the other hand, if the commission decided that it wanted to expand its policy, Cimerex submits that this would help the commission. It would benefit the commission in a number of ways to help them pursue the goals of the Oil and Gas Act. Then those factors could be used, and they would be strictly applied, and they'd be narrowly tailored, but they could be used to triage applicants, and then summarily dismiss those that do not make the threshold. So yes, I do think the statute, the standard of that particular case, new information energy versus Vancy, is whether or not in the end the party participated in a legally significant manner within the case. And that tracks the regulations about whether to make how to make an appearance. You make an appearance within the case, and you know, so what Cimerex did was they were diligent. And they made an appearance before the case was closed. They submitted the basis and new evidence of the wrongdoing that Colgate committed against its misfeasance against Cimerex. Colgate had an opportunity to respond to that and show evidence to the contrary. They did not. In fact, they acknowledged that it was a failure, but their only excuse was that the failure should have been addressed at the hearing. You know, we showed that there's sufficient evidence to reopen the case. But there's, in this case, there's really no need to reopen the case because the case was not closed when Cimerex made the appearance. So I would say we satisfy all those 4 threshold factors. And therefore there's really two bases on which the commission should grant the de novo hearing. One basis does not change precedent at all. The other basis expands policy a little bit, but we believe it does it in a favorable and beneficial way.
Thank you. Mr. Hadia, sort of, again, talking about that test that's laid out in the new energy economy case. Do you believe that Cimerex met that test in participating in a legally significant manner?
Madam Chair, you asking, if you're asking Adia, I say no.
Can you explain why you say no?
Well, he just didn't hear at the hearing. And actually, I think the order was issued the same day Cimerex filed for a de novo hearing. So had there been something significant that or deficiency in the hearing, I don't think the division is that busy to where it can't make that distinction at a hearing. For one thing, at all hearings, there's a technical examiner and the procedural examiner. I don't know which of the examiners was here, but I think Commissioner or Hearing Examiner Worth is very thorough in terms of procedural matters, and I don't think we can escape anything with the technical hearing examiners that participate in these hearings. And often there are more than just the two people that are generally assigned to each case. Often there are 3 people who participate in the hearing process. I know Ms. Murphy is very keen on catching stuff if she's on that, if she's hearing cases, or if she's in participates in any hearing, even if she's not the designated technical examiner. So it's not like we go in there and Colgate went in there and hoodwinked the division into granting an order. I don't think that ever happens. And yeah, I think they're busy, and I think it's harder in terms of virtual hearings, but you can't escape the notice issue. I would readily concede this case that if we were involved in a notice issue.
Thank you. Those are my questions for the moment. Commissioner Bloom, do you have questions?
Yes, Madam Chair, thank you. Mr. Padilla, looking at going back to let me find the document. This is Cimarex's Mr. Savage's closing brief, page 2, procedural background. I'm going to read this. So Mr. Savage writes, the touchstone for obtaining a compulsory pooling order pursuant to the New Mexico Oil and Gas Act, or Act, is the statutory obligation to seek a voluntary agreement with working interest owners as required by NMSA 1978 70-2-17C and related regulations. At a minimum, an applicant is required to provide, quote, evidence of attempts the applicant made to gain voluntary agreement, including but not limited to copies of correspondence, end quote. NMAC 19-15-4-12A B6. Let's see. The obligation to engage in good faith negotiations during the time prior to filing an application for a compulsory pooling order and leading up to the hearing is illustrated by recent decisions of both the division and the commission in order numbers R-20223 and R-21416-A respectively. Colgate LLC did not have standing to apply for, let alone receive a pooling order because it ignored its statutory and regulatory obligations, never made an attempt to enter a voluntary agreement, let alone engage in good faith negotiations to reach such an agreement. Mr. Padilla, can you react to that, please?
Mr. Examiner, I did not handle this case before the division. In reviewing the record, Colgate always submits a summary of contacts, and that is prima facie evidence of good faith in terms of making contacts with the parties that it is trying to pool in a compulsory pooling case. So I can't speak to my handling of the case or anything, but I do know that every case that I've handled for Colgate has been, I've always included an exhibit indicating a summary of negotiations. That is prima facie evidence that has to be rebutted at a hearing by somebody who disagrees that that does not constitute good faith negotiations. So that's why Cimarex needed to have challenged at the hearing the contention that Colgate did not deal in good faith or did not seek to obtain voluntary joinder.
Thank you, Mr. Padilla. Mr. Padilla, a couple other, I guess, moments in the record here that show perhaps a lack of communication between Colgate and Cimarex. One of these is Exhibit 1 to Cimarex's application for de novo hearing and the application to reopen. It shows the limited extent of the email exchanges between Colgate and Cimarex. And there was also, Exhibit 2, where we see Prosperity Bank stating that Colgate told the bank that it had not been able to attain, quote, a voluntary agreement from Cimerex. Cimerex asserts that Colgate did not make attempts to reach out to get this voluntary agreement. Any response to those allegations or concerns, Mr. Padilla?
Well, as I said in response to your earlier question, is that those things, if there's disagreement as to whether or not, whether the statements that Colgate made were erroneous or deceptive, then those have to be challenged at a hearing. I mean, you go to a hearing and say no. Colgate did not try, for example, did not send us a joint operating agreement or things of that effect. And so you make a case, you have to make a case that there was not any good faith, but if you don't participate, then I think this whole discussion of party of record is very clear, contrary to what Mr. Savage argues. But I think once an order has been issued, it's very easy to appeal a case to the commission, but you can't do it after the fact. We cited in this last supplemental brief Gila Resources Information Project versus the New Mexico Water Quality Commission. What I cited was a paragraph in that case that says, any party who participates in a permitting procedure before the department may appeal the department's decision by filing a petition for review before the commission. That's exactly what we have here. And earlier in the rulemaking procedure, and I'm not trying to get into the merits of this case. The fact of the matter is that, and I don't think the motion initially was to reopen this case. That was denied by the division. And I think it was denied correctly because they did not participate in the hearing. Now, if it had been a notice issue, then I think the division would have had to reopen the case. But to argue that they didn't comply on substantive issues that Colgate presented at the hearing is no excuse for not participation, for not participating.
Thank you, Mr. Padilla. I hear you loud and clear on the concerns about party of record having entered a appearance. I guess the last piece of the record I want to look at here is also from Cimerex de novo, or request for a de novo hearing. And that's on page 7, paragraph 6. It says Colgate's landman falsely testified that its case, quote, involves a request for an order from the division, compulsory pooling of interest owners who have refused to voluntarily pool their interests, end quote. Affidavit of Mark Hajdik, Exhibit B, paragraph 3. Goes on to say, however, Colgate never made the prerequisite attempts to enter into a voluntary agreement with Cimerex and never made good faith efforts to engage in any prior negotiations for that purpose. Therefore, Cimerex was never provided the opportunity to refuse or fail to enter a voluntary agreement as is required under the pooling statutes and regulations before an application for a pooling hearing can be submitted and qualify for approval. Again, Mr. Padilla, any reaction to that? And then I'll ask Mr. Savage for his response.
Well, I think my answer is pretty much the same as what I've responded to you before, is that you have to come into a hearing and say, they only contacted once or twice or something like that. They sent us an email, and that's not good enough. Colgate came in and said, we attempted to get everybody hooked up in drilling this well. And somebody's got to come in and say, no, you didn't. And in this case, Cimarex didn't come in. And what I'm arguing essentially is that Cimarex had a system for culling their applications, and they messed it up. They did not, that's not Colgate's fault. And I think if you go by the rules, the procedural rules, you have to appear. And I don't know, I can't speak to whether or not good faith was actually done by Colgate. And that's something that has to be tried before the division in a compulsory pooling case. Nothing was said by Cimarex at the hearing until way after, when they said, oh, we blew it. And that's jurisdictional.
Yeah, thank you, Mr. Padilla. And I hear you on those issues, and see where you cited the Gila Resource Information Project case. And on the other side, of course, we have New Energy Economy versus Vanzi. Mr. Savage, any reaction to the questions or information that I posed to Mr. Padilla regarding lack of outreach to working interest owners here?
Yes, thank you, Commissioner Bloom. The first thing I would like to say that if it's conceded that we can't determine whether a good faith effort was made, and Cimarex shows clear evidence that a good faith effort was not made, and the other party acknowledges that that may be the case, I believe that it can be established that good faith was not engaged in, and therefore the requirement of their standing to receive a pooling order under the statutes is clearly eliminated. And I think, that is very significant. Looking at the summary of contacts, when Cimarex first discovered that the hearing had been held, and when they talked to their former counsel and found out, the misrepresentations that Colgate had made to its counsel, which was also the counsel of Cimarex, and then they began looking into the hearing itself and the proceedings. They contacted us, and we started examining the exhibits, the summary of contacts, and we noticed that the contacts extended well toward the beyond what the emails of record represented, and so we saw these as misrepresentations made to the division, and this also occurred with other owners, and I think that was clear in the filings made by Brent McDonald of Prosperity Bank. And then when we looked into the actual exchange attempts or lack thereof attempts to enter a voluntary agreement, we looked at Colgate's testimony in the case, and that also appeared to be a misrepresentation, asserting false claims that that the emails and the correspondence and record of communication did not reflect. Commissioner Bloom, I mean, this, you can look at the behavior and the actions of Colgate in this case, and you can actually see a template for what has become often the practices and strategies that parties are taking before the division and the commission, and that is they send out a well proposal well in advance. They file new, and that would be a one of many well proposals. Some of them will go to pooling, some of them won't. A lot of them won't. Colgate's known for, as we understand, sending out lots of well proposals, and not all of them go to hearings. So Cimarex was involved in trying to manage the well proposals. And then it seems like, and you see this in a lot of examples, that the applicants or the parties who sent out the well proposed the well, they kind of lay low. They lay low and they try to avoid, communicating and emailing unless the person who receives the well proposal, reaches out, and Cimarex did in this case, and received one response after Cimarex initiated the communication. And so, and then they send out notice, and yes, notice is important, but what's more important is the overall framework of the Oil and Gas Act. And so once the party gets past notice, that formal notice, they're home free, and they can avoid both the letter and the spirit of the Oil and Gas Act. If the Oil and Gas Act, the way it's set up, if the Oil and Gas Act was truly pursued in good faith and followed, there is no reason why any owner of any interest, but especially a substantial interest, would not be fully aware of the efforts leading up to the hearing of the applicant to develop the unit in good faith. I mean, there's all kinds of complicated issues that need to be discussed. Not only, of course, the primary interests of waste and correlative rights, and the parties are very much involved in the economic interests and their self-interest, but there's also a lot of other liabilities. There's some environmental concerns. There's a whole set of factors that the parties need to be encouraged, and they need incentive to discuss these matters prior to a hearing. And the ruling in favor of Cimarex today would establish that incentive. It really would establish that incentive that from this point on, all applicants would know that they need to engage in a good faith manner to address all the concerns that the parties face prior to a hearing. And I think this would only benefit the division and the commission. And I think after this ruling, I think that no other party would again fail to submit all the documentation for a complete record. And I think those are important factors in the equation for this decision.
Okay, Mr. Savage, thank you. Mr. Padilla, thank you. Madam Chair, no further questions at this point on my end. Turn it back to you.
Thanks. I just actually have one additional follow-up that came out of the questions. So I think, Mr. Padilla, what you have asserted is that Cimarex should have, if they thought that Colgate had not, met their obligation to negotiate and agree upon something ahead of time, that Cimarex should have appeared at the hearing, and that would be the place to rebut it. Is that correct?
And that's correct. And, it's and let me comment on Mr. Savage's latest thing, saying that the division essentially is running some kind of corrupt procedures here in terms of for compulsory pooling. That there are a lot of factors. Of course, there are a lot of factors, but those are generally addressed. For example, on federal lands, if there's some area that needs protection, you got to move surface whole location or something. So all of those things are looked at, and that includes state lands where the regulatory agencies have jurisdiction. But to say that the OCD is running some kind of corrupt, I take it that way, is that companies are not doing it right, and that if you reopen this case, then you would correct all sorts of division practices that are not proper. I don't think that's correct. But going back to your question, I don't think, and I think that you have highlighted the participation in a significant manner. There's been no participation in the new energy case. That's a great case for us, because and I have to go back to your rulemaking case where parties have to register. People have to register to present technical evidence, and that's in a rulemaking procedure which is less stringent in terms of notice and participation. But you have to require some kind of sign up. You can't simply ignore proceedings and then not come in and say, I disagree. And Cimarex should have done that. If they had done that, no question, and the order issued against for Colgate, then they would have the right to de novo hearing before the commission.
Okay, so I want to go back to my question real quick. And so
Madam Chair, I'm sorry. I really feel like I need to respond to that allegation. That
can we respond like at the end? I'll give each of you a brief moment.
I think it's important. If there's accusations that I am saying that the division is corrupt, that is not true in any way. And I will explain that, and I wish to have time to explain that. Thank you.
That's fine. I'll give each of you a couple minutes at the end after I just want to finish my questions. Okay, so Mr. Padilla, what I understand is you said to my question that you believe if Cimarex thought that Colgate had not sought the voluntary agreement with working interest owners as is required by 70-2-17C, then their obligation is to rebut that at hearing. Yes or no?
Yes.
Okay. So is it not though the obligation of the applicant at that hearing, which would have been Colgate in this manner, to accurately represent whether or not they sought a voluntary agreement with working interest owners as is required by 70-2-17C? Yes or no?
Yes, but let me. Yeah, they have that obligation.
Give me a moment here.
Yes, they do. They have that obligation.
Okay, so if that information was inaccurately represented, then wouldn't that be an issue on the applicant, in this case Colgate, if it's misrepresented? I'm not saying it was misrepresented. I'm saying if it is misrepresented. Yes or no?
Yes, if it's misrepresented and it's false, then they're not entitled to that. But it's up to the trier of fact to decide whether or not that representation is accurate. The division
Okay, so-
obviously thought it was accurate.
And am I also correct in saying yes or no? You said earlier that you aren't privy really as to whether or not the information that was represented at that hearing was accurate. Yes or no?
Yes, it was accurate. I mean, I didn't do that case, but I'm defending that case, and my review is that it's accurate.
Earlier, it sounded as if you had said you weren't a part of that case, and so you can't, fully represent what was said there. Is
Well,
that accurate or not?
Well, I have to go by what's in the record, and the practice and procedure where I've handled Colgate cases in the past, I've been satisfied with what they presented. In terms of making a case, I just had a case yesterday where the mineral owner was not given a proposal, and we're going to hearing next week, but obviously we have to explain that to the division.
Understood,
they
Mr.
can't-
Padilla. I think you answered my question.
Okay.
All right, I have no further questions at this point. Commissioner Bloom, do you have anything further?
Madam Chair, I do not. I have no further questions at this point.
Okay, Mr. Padilla, you've got a couple minutes if you have anything final to say.
No, I think I've argued this case, and I didn't mean to attack Mr. Savage as, and probably my characterization of his comments were that I didn't to say that companies are corrupt in their practices. Let me put it this way, not the division, but companies are corrupt in their practices. I think there's a lot of competition out there between companies in terms of assuring that nobody gets away with anything before the division. To say, but I do think it's disingenuous to say that companies traditionally come in there and use the division as a means to acquire properties. I've had that argument in the past, and I mentioned earlier, I was in court in the federal district court against Cimarex. Basically, they were filing a pooling action on the same day that they sent out a proposal, and that's why this idea of 30 days between notice and an application for a hearing, that got instituted because of that kind of practice. So I think the division at some point catches on to anything that is not kosher. So I don't know. Maybe my characterization was too broad and too pointed, but yeah, I think if somebody comes in there and says a well cost, in one case they said a Wolfcamp well cost $16 million, and I want to cross-examine that landman, and who said that in an affidavit, but I was participating in the case.
Thank you, Mr. Padilla. Mr. Savage, do you have anything? I think you do. Further to say?
Yeah, thank you. I just want to say I appreciate Mr. Padilla acknowledging that I did not say or claim or assert that the division is corrupt in any way. I think the division does a lot of good work. It's hard work. It's technical. They give good feedback. I've had good experiences with the division. They've always been up front. And I shouldn't say there's incentive in the process. I should say there's opportunity at this point in some of the proceedings if the parties choose in bad faith to pursue those opportunities. And I think that this particular case represents facts and circumstances where it seems clear that Colgate has abused the process. And the division would never have known because they take the testimony as being true and accurate, and they should, because we're all under ethical obligations to provide that to the division. But once that has been exposed as not being accurate or factual or misrepresentation or false claims, and once it has been exposed that the applicant has not met the statutory criteria, I think there needs to be some kind of mechanism in which the division or the commission can address those concerns or the disclosure of those facts. And so I really think this is like an important case to continue. I mean, the division and the commission, they've raised standards, they've implemented more accountability, they've increased policy. I think this is an important step in that ongoing process.
Thank you, Mr. Savage. All right, Commissioner Bloom, I think we're up. I think for me at this point, it all hinges upon really the good faith effort and the obligation to seek a voluntary agreement with working interest owners, as is required by 70-2-17C. While I understand Mr. Padilla's statement that Cimarex, their best opportunity to rebut, whatever Colgate is saying is at that hearing, that division hearing. I also think the obligation is on the applicant to present factual and accurate information. And whether that was done or not, I still feel somewhat unclear. Cimarex is asserting they haven't. Colgate is saying, well, maybe we have, but I can't exactly say. I feel like there's still uncertainty in that factor. But I feel like there's enough uncertainty and enough potential. There's enough potential that the division order should not have been executed, that it is worth rehearing and having a de novo appeal. But I welcome your take on it.
Madam Chair, thanks for the comments. I agree with what you just said and would second that. I think obviously one of the major responsibilities and sources of power of the OCC is our charge to prevent waste and protect relative rights. And I believe the best way to prevent waste in this case is to grant a de novo hearing on this compulsory pooling case. Having the two largest working interest owners, if not others, involved in this in a new hearing would make sure that we get the best plan for this pool and potentially prevent any waste or minimize waste. And I'll just say for the record that I don't want to see OCD hearings being used to unfairly to get a compulsory pooling ruling. that's not what this is here for. And if things aren't done correctly, we end up in these sorts of situations. Madam Chair, that's all I have. If you'd like, I'd be glad to introduce some motions. Vote on.
Yep, go ahead.
So, Madam Chair, I would move to deny the motion to dismiss the application for de novo hearing.
I second that motion. Mr. Melander, would you do a roll call, please?
Yes, Madam Chair. Commissioner Bloom
Yay.
and Madam Chair.
Agree.
The motion the motion passes, denying the motion to dismiss.
Mr. Melander, if I might, Madam Chair, would I need to move to grant the application for a de novo hearing?
That would be the next step. And then, yes, then subsequent, or well, following that, the motion to stay, because that would be procedurally proper.
Then, Madam Chair, if I might, I would move to grant the application for a de novo hearing in this case.
I second that motion. Mr. Melander, would you do a roll call, please?
Yes, Madam Chair. Commissioner Bloom.
Agreed.
Madam Chair.
Agree.
And then finally, Madam Chair, I would move to grant the stay petition for by Cimerex.
I second that.
I would recommend, I'm realizing, that it does seem fairly logical to grant the stay at this point. I'd recommend soliciting the parties for anything beyond their motion, because I think the motion, response, and reply were pretty straightforward. There isn't a lot of complexity in any of those, at least from my perspective. So I would solicit any brief comments the parties might have about the motion for stay before rendering or moving and or rendering a final decision.
Okay. Mr. Padilla, taking into account the motions that the commission just made to grant Cimerex their de novo application, do you have any comments on Cimerex's request to stay the division compulsory pooling order?
Well, I don't know what my client wants or Colgate wants to do, whether once an order is issued, whether they want to ask me to do a motion for rehearing that I have to necessarily do if they want to proceed to the district court. I think it's fairly clear that and I'm not going to argue anymore. You've made your ruling on the motion to stay. I just defer that to the commission, because I know that Colgate is already moving down the line and has already sent well proposals under the order, and I don't know where they are in terms of actually preparing drilling of it. Theoretically, that order is still valid unless you stay it.
Thank you, Mr. Padilla. Mr. Savage, do you have any comments?
Oh, just briefly. I mean, there was mention that acknowledgement that the order shouldn't have been issued under the circumstances. I think there's a risk here to, if without the stay, to act upon a questionable order. Commissioner Bloom brought up questions of waste and correlative rights that are still outstanding. To me, it's a safer route. It's to exercise the precaution to avoid any decisions that would undermine any issues at issue right now.
Thank you. I don't have any questions. Commissioner Bloom, do you have any questions?
No, no questions. I would be interested in seeing this stay passed so that there are not irrevocable changes on the ground that would make our previous votes meaningless.
I concur. I think the stay, I mean, it's the right decision, and considering that we're granting a de novo appeal at commission, it doesn't make a lot of sense to me to continue to allow the division order to stand. And so I think having a stay is the natural decision. I guess, should we remake that motion?
Yes, Madam Chair, I'm glad to move to grant the motion for a stay in this case.
I second that. Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom,
Agreed.
Madam Chair,
Agree.
the motion passes.
Is there?
I do have one comment or request I'd like to make. Mr. Padilla, whatever your client decides to do next, if your client decides to proceed to district court, will you please be sure to put me on the, oddly enough, the service list as counsel for the commission?
I think the commission would be a party at this point if we're asking
Sure.
to the, so yes, you're on the notice list.
Awesome. And I only say that because on occasion, sometimes people have forgotten or they don't even know who the AG is that's handling those things. And in this case, we do, and it will make everything smoother. So I appreciate that. Thank you very much.
Thank you.
So at this point, Mr. Moander, do we need to discuss scheduling at all, or?
That, I think at this point, this might be something, and I hate to drag the parties back, but it sounds like Mr. Padilla in particular has some homework he needs to do. And I'm always open to the parties' positions, but I'm thinking that this might be worthwhile to discuss scheduling in May. But again, I'm available for everybody. Everyone's not available for me. So I think that's something just to briefly discuss on what should be done next, or the parties and the.
Madam Chair, there is one other matter that's associated with this that I'd like to address, and it involves potential scheduling.
Go ahead.
So we had competing applications at the division level that were designed to address the de novo hearing. EOG made an appearance in that case, and they did a motion to dismiss those cases. Those the well proposals were sent by Cimerex, and even updated well proposals were sent, and we were negotiating with the owners, including EOG, but because of the extenuating circumstances of the competing applications and the issues involved, there was time constraints in which we were participating in that, and EOG raised concerns and that there wasn't enough time to do full good faith negotiations. To address those concerns, we voluntarily dismissed those cases. Those cases are integral to the matter at hand. We would respectfully request some opportunity to send out the well proposals or continue the negotiations and resubmit those applications as competing applications with Colgate's.
Okay. I mean, Mr. Moander, do you have any thoughts on that?
So here's the issue that I'm seeing sort of developing here is it makes sense to want to get all parties who may have some degree of interest brought in as needed. On the other hand, at this point, I'm suspect about negotiations, but I never discourage them. But given the potential that Colgate is purportedly moving forward to some extent. I would not want this to go very long, and that's why two thoughts. One, I'm going to request that the parties keep me updated as to what's going on with this case, to reasonably so. The other thing is that it sounds like there may be a value in a status conference in May, so that way by then I would expect that Colgate will have made its decisions and that Cimarex would have reached out and at least have, if necessary, have some evidence supporting their effort to try to bring in the parties who need to be in the case, in order to really get a handle on the size of hearing that may be needed, realizing that all pooling hearings are pretty big. I think that doesn't, because I don't want to hamper Colgate any more than under the circumstances than they are, but at the same time, I do think that it's valuable to make sure everyone's brought in to avoid any further issues with notice and party of record, et cetera. So that my proposal would be a status conference with the assumption here that in probably 2 weeks, I would hear from the parties respectively about what's going on.
I think that makes sense. We could schedule a status conference in May and if needed, continue it.
Madam Chair, will we go ahead and have permission then to refile the competing applications in preparation of that status conference?
I see no issue with that, Mr. Moander.
We're getting all sorts of, I'm decent with the rules, but you guys are bringing up some pretty narrow stuff on me. I'm like, well, damn it, I don't have the right answer for that.
If I could, oh, go ahead. I'm sorry.
Oh no, Mr. Savage, I'm all ears with party counsel to help me help the commission.
Well, there is precedence for this. In the recent past, orders have been stayed to allow all the parties to file applications and have them in place for proper de novo hearing procedures. I think this is a case that justifies that. That would have been had the original case proceedings have they been pursued in conformity with the statutes. The competing application, then Cimarex would have submitted applications. So basically, this is restoring things to in normalcy in preparation for the de novo hearing.
Mr. Padilla, aside from the motion to dismiss and in reference to competing applications, do you have any comments?
Well, it's as you said, I have homework to do in terms of finding out, for example, whether or not Colgate has, it could have actually started the well for all I know. And I'm not trying to sound ignorant about that. I don't know what kind of preparations they have been doing. I know that they have sent out notices under the order to participate in drilling the well or wells. I don't know what kind of money has been expended. I do know that there have been negotiations between Cimarex and Colgate, and there would have been a trade-up. But apparently the Colgate interests are burdened by some kind of an agreement with Apache that they have to, the holder of that interest has to abide by something that Apache requires, and that's not acceptable to Colgate. So there are a lot of things out there, but in any event, I guess what the case would not be ripe until after for a rehearing, until after the de novo hearing is held, simply because it's not the final decision, so that we could exhaust our remedies.
So it sounds to me, Mr. Vidia, and obviously correct me if I'm wrong, that additional time for other parties, whether they're competing applications or otherwise, is warranted here. Is that a fair description?
I don't think Colgate's going to agree with that, but I think they have to accept the commission's ruling today. And if there's a stay order, I think I would simply ask that those orders be entered so that we could decide one way or the other what we're going to do with it.
Okay.
Mr. Miranda, if I may add one more thing, if we could go ahead and file the applications, Cimerex would cover the cost of any continuances that needed to be put in place while the matter is being decided or the issues being decided at the status conference. And if in the end, for whatever reason, there needs to be like some change of direction, that can be addressed at that point.
Okay. That sounds good to
I
me.
mean, that
because
makes sense to me, Mr. Molander.
I think it's sound. And in reviewing the rules here in front of me, I'm not seeing anything that in particular sticks out that's going to prevent that or cause an issue. So, and this is all the more reason for everyone, all the parties to stay in touch with me. So I got a sense on where things are headed or not headed.
Okay. So do we need to do any sort of motion on this status conference or no?
At this point, no, but I would suggest that the commission formally take action to grant, let's see. Actually, no, we're good at this point. So if any competing applications are submitted, we'll deal with those at that time because those are non-existent at this point. So I think we should be good at this point, and we're just going to have the status conference set for May.
Great.
Procedurally, I have a question. With those competing applications have to be heard before the division first?
I would think so.
Let me look here.
Madam Chair, I believe the commission would have discretion whether to send them down to the division to be heard or whether to accept them to be heard within the de novo hearing, because it does concern the same matter as the original hearing, in my opinion. So I believe that there would be discretion there, but of course the commission would have to decide that in the end.
Mr. Molander, does that make sense as to something that's decided at the status conference? The commission does always have the option to pull items from division.
Yeah.
As they see fit. But
I am not prepared to render any guidance on that narrow issue today.
I would like to discuss that at the status conference. And maybe coming prepared, Mr. Savage, to discuss as to why or why not it is appropriate. The commission always has that option, but whether we choose to invoke it or not is our discretion.
Yes, yeah, thank you, Madam Chair. I don't think it's an unlimited option, but I think if the circumstances and facts are correct and aligned, I think that there is that option. So I'd be glad to discuss that from my perspective.
Okay. All right. Anything else in case number 21744?
Not for me.
Nope, thank you.
All right. As stated earlier, agenda items 6 through 9 were continued to the July 8th docket. Mr. Molander, is there any updates on pending litigation?
Very briefly, Madam Chair, still haven't heard anything from the Court of Appeals about the marker appeal. The deadline for filing the docketing statement by the appellee was March 19th, and we're about a month out. So I'm hoping to hear something soon, but right now it's still in limbo and nothing is yet docketed in any way.
Okay. Is there any other business in front of the commission? All right. Our next meeting is on May 13th. Mr. Savage and Mr. Padilla, we will see you then. Third time in a row here. And with that, it is 11:48 and we will adjourn the meeting today.
Let me, so May 13th is going to be a status conference, is that?
Correct.
Okay.
Yes.
Okay, thank you.
All right. Thanks, everybody. Have a good day.
Bye.